Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-L-E?
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do we need to see?
All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Tuesday afternoon to you as we get set for part 2 of day 26 in the Karen Reed trial, round 2. Big shout out to, not sample user, no, to Willow Johnson. Willow, congratulations. First in chat today. I think this is the first offense for you. This is the first time you've been first in chat, according to my records, which means you are going to be celebrated and simultaneously punished for your good deed. You broke the stillness of the chat room. You were so exuberant, so excited to get everything going that you clearly have enough energy to handle all the problems of the internet. And so we're sentencing you to internet ownership. That's right. Everything IP-related worldwide is now your responsibility until we go live again tomorrow morning. So good luck with that. You're going to do great. You can do great. First day jitters, I'm sure, but you'll be fine. You'll be fine. Congratulations, by the way. Thank you for being first. All right. You guys asked, a couple of you asked to go back and see a little bit from the testimony we had. As soon as
we're not going to argue about semantics here.
We're not going to argue about semantics. As soon as Mr. Brennan, why is Britter in my head? What is even Britter? I don't know. As soon as Mr. Brennan started his questioning today, he brought the heat, and a couple of you asked to go back and see what happened. So what initially began is he started questioning Dr. Russell about stuff, and she asked for a copy of the transcript. And this became a heated issue as he started asking if somebody had talked to you about asking for a transcript every time I bring something up, because last time it made him look a little silly because he didn't have it and it wasn't there. And she said yes. She said overnight between last night and this morning, I talked to Attorney Alessi, and he told me to ask for a transcript about every time he brings up a past testimony. So she starts doing this, and Mr. Brennan is trying to get to the bottom of this conversation, how it began, and that's where we pick it up right here. Here we go.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning,
Fantastic.
About your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
Do you have any memory issues? Oh. Now you're in the not. Guess who's not getting a Christmas card this year, Mr. Brennan? Guess who's not getting a card? Yeah, it's you. You are off the list officially. He said, do you have any memory issues? Yeah, how rude. How rude, right? That was the response. Anyway, so that happened. Meanwhile, we're waiting for court to start right now. We've had a long break, a sidebar into lunch. We sideswiped lunch with our sidebar is what happened. And so we've had a significant little break here. We're waiting for about another 10 or so minutes, roughly, to see if we start up. Can you play it again? I was lagging. I lagged too, unfortunately. Just 1 second. Let me rewind just a tiny bit. I'll play it one more time. Ready?
You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Oh, she's mad. Look at that frown. That is a stern look. You don't want anyone to give you that look, let alone Dr. Russell. Anyway, that was what happened there. New soundbite. Do you have any memory issues? Who gasped so loudly? The witness did. The witness did. I'm sorry. I'm recording and playing off the same hard drive right now, so that's causing a little bit of a lag. Maybe we could switch that up, but there's a new defense motion to reconsider the testimony of Michael Easter. I saw that. We've got a couple motions. I actually wanted to talk briefly about. Let's see. I think Amber sent it to me here. Okay, I want to talk about this one. This is the defendant's motion to request for a missing witness instruction. And wow, it's tiny. How do I? Must be bigger. Send it to a computer so I can read it properly. Send it over here. All right, I need to just shrink down our tally counter. We're at 226 as far as the side counter goes. I am keeping track of those, even though it's not on screen. Let's see. I'll bring this over right here. You guys see this? It's tiny. I'll make it bigger. I'll embiggen this. Let's see. If we scroll down to the bottom, I think. Oh, why is it not doing a continuous scroll? There we go. Okay. If we scroll down to the bottom, I think we've got today's date on here. Way down here, past the redactions. That's page 5. More. Let's see. I think it's today's date. June 2nd. That's today. All right, let's go back up here. This is a defendant's motion to present a missing witness argument. And I'll get this out of the way. To present a missing witness argument and a request for a subsequent instruction. Now comes the defendant, Karen Reed. I need to, hang on 1 second. Let's, I need to be able to see that. Well, this will work. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to allow for the use of missing witness argument and subsequent instruction in her defense. All foundational requirements for a missing witness argument and instruction are met. Allowing Mrs. Reed to present a missing witness argument would best position the jury to consider all the evidence at issue, including what is missing from the Commonwealth's case, in their deliberations. All foundational requirements for a missing witness argument and instruction are met. It's appropriate for the court to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward, who is friendly to, or at least not hostilely disposed toward, the party, and who can be expected to give testimony of distinct importance to the case. The party would naturally offer that person as a witness. If then, without explanation, a party does not call the witness to offer testimony, the jury may infer that the prospective witness would have given testimony unfavorable to that party. And we've got some case law. The underlying premise of a missing witness instruction is that the party's failure to call a prospective witness raises a reasonable inference that this witness would have provided testimony adverse to that party, and a jury should be afforded the opportunity to consider that information in their deliberations if they deem it to be reasonable. A trial judge has discretion to refuse to give missing witness instruction requested by either party. However, cases supporting the need for judicial caution in permitting these adverse inference are inapposite when the inference is to run against the Commonwealth because there are no constitutional concerns to warrant the call for caution in such instances. Notably, the degree of judicial discretion may be lessened when it is the defendant rather than the Commonwealth who seeks approval of a missing witness argument. Whose names are on this? Michael Proctor, Brian Albert, and Brian Higgins are all available and friendly to the Commonwealth. This goes on to say that all 3 witnesses testified in the first proceedings. There's no reason to believe the individuals would not continue to be friendly that way. They were not produced by summons or otherwise during the trial. There's been no showing of physical unavailability for any of these witnesses. They were actually even under subpoena by the Commonwealth. Additionally, the fact that Ms. Reed could call these witnesses does not render an adverse inference impermissible because the Commonwealth is more acquainted with these witnesses and would be naturally expected to call them in establishing their case in chief. A missing witness instruction may be properly given where the prospective witness is more friendly to one side than the other, even if the witness was available to the party requesting the instruction. So that is the missing witness issue at play. Defense wants this instruction. This would be something that the jury is read by the judge, and then the defense would be allowed to make the argument that that you can infer something harmful towards the state, the Commonwealth, because they were not there. So that's fascinating. Fascinating. They potentially could do that and call them. They could potentially do that and call them to the stand. All right. Definitely part of the chess game for sure. See, Phil says, all right, I'm sending you a taillight teeth kit, adhesive vinyl. Phil, make sure you get it in Lexus size. So it's, I've seen the teeth on Twitter. They look great. It makes it really look like a taillight could just reach out and bite you. But I think maybe we'll put the teeth on. My idea for this taillight, by the way, the Lexus 570 taillight, is to cut the seam all the way around the outside and try to take this apart in as large chunks as possible, preferably in layers. So I do have a reciprocating saw, like a little a multi-tool that just you attach blades to and it cuts very fine cuts. So I'm going to try to do that around the edges and not break anything. I think it's pretty sturdy, so it should be all right. We're going to take it apart and see if we can have a outer layer, a diffuser layer, and then the LED and inner housing in 3 separate layers. We'll see what happens. But that's where we are with that one. Can't wait for it, Phil. I'm super excited. It's like arts and crafts, yes, but with taillights. Okay. Anything else we needed to go over? I'm trying to think of what else to talk about as far as the proceedings this morning. If you smash your underarm into the light in 24 miles per hour, do you get bruises? Live testing. I've thought about that, and it's a great idea until I practical. I have a difficult time hurting myself. It's not that my pain tolerance is ridiculously low, which it is, but that's not the reason. I just don't know if any testing I can do on that taillight would be more effective or more insightful than any of the tests which have been done by other either content creators or experts in this case. I don't think that I could do a better job testing this than Mr. Well, definitely not Arca, but the other dudes, Amcor, who were Bergner. Was it Bergner and Walsh? Can't remember. Brain is off today. I'm sorry. Didn't eat enough lunch. So we're going to do something a little bit different and just dissect it. I did just get a cable today. That's something I can mention. This is one of the shortest cables I own, and it's micro USB to USB-C. And this is for my drone to allow me to watch live video from my drone on my phone while I'm flying it, which will be necessary when we go up to Virginia. You used to be able to put lights in the oven and get the glue to loosen up and not have to cut them open. Cody, Two problems with that. Problem number one is it's Mrs. R.A.'s oven, and so help me if this stinks and smells like melted plastic in our house. I'll need a new house, and Mrs. R.A. won't be in it with me. So that's problem number one. Number two, this is really, I wish I could show you this in detail. It is bonded and really, it's not just glued. The layers of plastic have completely been melted and sealed together like that. It's not just glue. This is pretty impressive. But maybe a heat gun. Maybe if I go to Harbor Freight, I can pick up a heat gun and try that. I think RA just likes his tail light. Well, I know whatever I do, I pretty much only get one shot at it. And I don't have a heat gun. Can I steal a hairdryer? We've got a hairdryer in the Airbnb. Maybe I'll steal that one. No, I've got a renter. I can't go in there. Why do it that way? Seeing what it is in it doesn't help, does it? A little bit, Virginia. It helps us understand, especially the layers, the spacing of the layers inside, and the orientation and the configuration of the lighting inside, as far as where the lights are, how they would look with different layers on or off. So I think it has some good purpose there. Plastic fumes are toxic, yes. Sneaks quietly into retrieve hairdryer for science. I like using Harbor Freight for tools that I know I only need to use once. Get a Walmart hairdryer. Arm straight, doesn't that spread the force? Tony, you're right. Today is, in fact, the 3rd. This was yesterday's filing. It was just filed this morning, or just posted this morning. You need a heat gun that can get hot enough to melt plastic. Then I'm going to need, ventilation and everything.
In front of the Walmart.
Okay, let's close that out. Bring back our counter for the day. You guys will see here, I have kept the counter off the screen. It's down in the bottom corner. Every time I hear a siren or a sigh, actually I'm late on one sigh. I was going to add it. It was towards the end, so I'll add that now. I'm trying to add it right there. So our number is 227 right now, but I'll leave it off the screen so we can pay attention to the testimony as it happens in court. Before you break it into a million pieces, ask Canton PD how they did it. Less impact to break anything other than the arm. Find out how strong it is. It's pretty sturdy. Hear ye, hear ye, hear ye. I'm sorry, Samantha. I did hide it. You're good, Samantha. I apologize. I do a terrible job communicating with you guys, and you do your best to guess at what I was thinking. And normally you're spot on. So my apologies. That was my fault. Who made it? This is from Lexus. This is an OEM taillight.
I'm not going to argue about semantics here.
Okay, we are just a couple minutes past the top of the hour, meaning we should be coming back. No, she didn't. Samantha makes me look good. Samantha is one of the reasons why this whole thing operates as smoothly as it does. Thank you, Samantha, for all your work, all you do. If you guys only knew on the back end what mods both do and what they put up with. First of all, no one would want to be a mod if you knew. It's like what it's involved. She's amazing. Samantha, thank you. She the best. She is. When is verdict? Marie, great question. I think the question we need to ask first is how much longer on defense? And the truth is we don't know. We don't know how many witnesses they're going to call, where they're going to say we've done enough. At this point, we want to stop and rest and let the jury deliberate. But we do anticipate at least 3 more witnesses that are on the schedule, some even today. Like Lucky, the snowplow driver, might be up next. But, yeah. They estimated 1.5 to 2 weeks. That puts us right on a little ahead of schedule, according to the judge. Oh, we've got a call that might be scam. I'm not sure. No, it's not scam.
From Selena.
It's from Selena. Hey, Selena, how are you doing?
Hey, I'm good. I just called in real quick to update my scooter catastrophe because
who let you drive? I'm sorry.
Warren,
we're back.
I'm going to lose my license. But anyway, court's coming back, but I did tip over on the cement. I scraped my elbow and my face, but my knee was okay. So anyway.
At least a dog didn't bite you afterwards.
Yeah, no dog come to bite me. A neighbor helped me pick me up. He was like, "You need help?" I'm like, "No, I can just lay here on the cement."
No, I'm just out here for the fun of it. Thanks, Selena.
Yeah.
Hope you get feeling better. We'll see
Bye.
you. Bye. Selena's area code comes in the same as the scammers, so I'm always hesitant to answer her call.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing. No injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay.
Mr. Brennan?
Could I inquire about scope?
Sidebar. He says, can I ask about the scope? Because I'd like to go into something. Oh, man. Yeah, he's got some questions. Wow. I just found, what's this? Oh, I just got one of these magazines that, thank you very much. Appreciate that. So these magazines come that, you know, when the magazine comes, you're like, hey, I want to save that one. I want to look at that one later. Yeah, I just got one of those. It's from B&H Photo, the show book from the Build Expo. It's all cameras and computers and cords and cables. Ooh, wow. This is good stuff. I'll save this for later. All right, step away from the magazine. I've spent all my money. I can't buy anything. I bought the e-bike. I'm done buying for the year, I think. But that's where we're at. The last little bit of money I have, I think I'm going to spend. I found Old Bay Goldfish crackers can be ordered online through Walmart. An e-bike, yes, an e-bike. Mostly because I have to haul. There's a video project I'm doing up in Virginia next month. I need to haul a whole bunch of gear, including battery chargers, and we have no generator power, so all my batteries, all my cables, all my cameras, tripods, microphones, any other accessory, boom mics, wireless mics, anything we need, plus my own gear. Myself all over a huge ranch, like 2,500 acre ranch up in Virginia, and we're not allowed to have four-wheelers. So e-bike was approved, so I got an e-bike that would hold me and all my equipment. I just have to pedal a little bit, and then it will do the rest of the work. So 2 turntables and a microphone. That's a good. What song is that? I know that song, but I don't know what it is. Sherry says, check your text. Somebody just texted, you got me goldfish. Sherry, that's awesome. If that was you. Oh, this is Sherry. I ordered you some. There you go. Check your post office box. Oh, thank you. This is the best goldfish ever. All right, sidebar. I'll say this about court. When we came back, Mr. Alessi won the objection that we were arguing over before lunch. Because he went right back to that same question, talking about that medical examiner's examination of the lower extremities of John O'Keefe's body. And there was an objection immediately and sustained by the judge. Went to sidebar. And now he was able to ask the questions and get the information that there was no internal or external visible injury to the lower extremities of John O'Keefe after the accident, which would be expected in a car crash situation. This is helpful for the defense, not so much for the prosecution. And and now that Mr. Alessi has basically said no further questions at this point, Mr. Brennan is asking about, what can I go into? Can you give me some guidance, Judge, as far as scope on this one? There might be something possibly that was discussed at sidebar that the judge says, I'm going to allow you to either revisit this or do something else because of a decision. So we'll see what happens. I do not anticipate her being a 2 to 3 day witness. It's definitely only going to be 2. If we've already had the second redirect conclude, I think we're very, very near the finish right now. Alessi did not go into DNA. I think it's very important that he did not. If he went into DNA now, it would basically be an adoption of the introduction. I think he has a stronger appeal on that issue by not going into it at all. So if he said, we never brought it up, it was only the Commonwealth, I would be very surprised at this point if the defense talks about DNA at all.
May I?
Yes.
The may I is short for may I inquire, asking permission of the judge to proceed with cross-examination of the witness.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question, so we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Could we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom, penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a
we're not going to sound
a movement. What they're describing is a move. In the way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that show up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity, I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay. There are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Alessi?
She wants to show the title. He wants to show a paragraph, the highlighted paragraph.
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do that.
Do you see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Objection, Your Honor.
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise, it depends on the location, it depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor. No, the objection sustained.
Thank you. When you came to your conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor. Sustained.
That's scope.
Finally, Dr. Russell, you said during your differential diagnosis you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor. I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection. Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. You know, do they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Okay.
Round 3 for Alessi.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California.
That is correct. It's the second one.
Little leading there.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Was leading.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for, and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of, Attorney Brennan asked you, and so now with regard to the Pollack article, in terms of the Pollack article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollack speak to that?
He does.
And what does Pollack say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay.
It's his
I didn't
paper.
know what you had.
Yes, thanks. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little bit.
Yep. Start back a second. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Commentary, I'd like to be heard.
Why don't you bring the reports over?
Oh, come on, pot and kettle. He says fair, and he's like, objection, I'd like to be heard, commentary. Okay, then we've had a lot of commentary from Mr. Brennan today, a ton. Mr. Alessi's just barely getting a word in, and he wants sidebar. Judge, he said fair. All right. It's all right. It's all right. It's all good. We'll get past this, and both attorneys need to stop doing the commentary. All right. Oh man. No, judge is not going to deny the sidebar. I think she's going to take all the sidebars at this point. We're almost done with this witness. Almost. Okay, guys. You can almost hold your breath because it's going to be pretty quick. Maybe the sidebar won't be, but there's not a lot left in this particular witness to ask about the back and forth with each progressive back and forth. The scope is narrowing more and more, and eventually there's just going to be nothing left to say. And at that point, this witness will be done, be excused from her subpoena, and she will be out and gone and free to go about her life and work as she sees fit. He said finally 10 minutes ago. Yeah, finallys happen a lot. I'm super optimistic. Oh, man. I wonder if Mr. Brennan is asking for overdier on this or something. Let's see if we panned up. That's usually when the jury leaves, but we'll see. It's also possible that we're panning up just because during the sidebar, members of the jury are more inclined to stand, to stretch. Some of them will stand during the testimony, as you know, whatever is most comfortable, and it's okay. The judge is fine with that. But during the sidebar, when jurors stand up in front of the cameraman has to pan up. All right, feel for this poor jury. I think the jury has got a good feel for what's going on right now. I think they're vested. All but one of them, I think, is all good with this. They're both getting their punches in. They are. Both sides are doing this. This is the game they've played the entire trial long. They've played this game, the back and forth, the jockeying for position, I'm only going to do the minimum required by the letter of the law, and you know, see how much I can get away with. They have done this all the way through since before the first trial. This is common. Update her resume to say can handle long and grueling testimony. I wish Mr. Alessi was better at direct questioning than he is. I really feel that Alan Jackson did a better job with this witness the first time around. I like all witnesses to give their best possible presentation to the jury, and I think part of Dr. Russell's testimony has sort of been diminished a little bit by Mr. Alessi's inability to progressively and logically and consistently move forward through the testimony. He's really good at cross, man. If we ever had a court case where everyone got to cross and everyone got to lead, first of all, it would be crazy. It would be wild, but man, he would be great at it. Yes, feel free to use the chat block feature. Please don't announce it in chat. If you announce it in chat, you might find yourself timed out. We find that those sort of comments do lead to other comments which are problematic for other people. So if you happen to make your feed a little bit nicer based on how you like to view it by silencing someone on your feed, just smile and enjoy it. That's all. What if the state and defense have drinks together afterwards? They need to congratulate each other on a job well done. Cat's Gallery, this is interesting. We've watched some very heated trials, and some of them, we'll even find out that even during open court discussion that the prosecution and defense are friends outside of court. They know each other. They have a lot of respect.
Thank you.
This one I don't think is the case. Obviously, a couple of the attorneys are from out of town, probably don't know each other.
Yes. Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh, and what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are
Now
all
she's
set.
done. All right. I told you you could hold your breath. We were almost done.
I'm going to have this marked for identification.
Thank you.
Mark it. Judges. What are we on? QQQQQ? RRR. I was so close. QQQQQ was taken. We're on RRRRR. The pirate one instead. All right, who's next? I think we got Lucky. I think we're getting Lucky. I think we're getting Lucky, the snowplow driver, as the next witness.
And the next witness is who? Who's the next witness?
If I may, Your Honor?
Yes, just tell me the name because I need to know whether we need to go to sidebar first.
Barrows.
Okay.
No, Officer Barrows, not Lucky. Officer Barrows was one of the 3 people who were mentioned as possibly being in the courtroom awaiting testimony today. My wife told a joke the other day. She said to my kids, she said, you should never date a tennis player because love means nothing to them.
Just how much of the evidence you give to the court and jury in the case down here and the truth, the whole truth, and nothing but the truth, so help you God? I do.
Maybe see.
Good afternoon.
Ooh, sharp suit. I like that look. I like it.
All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department.
How long have you worked for the Dighton Police Department, sir?
Since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police Department?
It is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I love AJ's style.
I want to draw your attention to January of 2022, a few years ago.
He's great at questioning.
January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dayton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to the location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dayton.
Ooh.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, did you, I don't want the address, cameras are rolling, did you respond specifically to a residence in the city of Dayton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
Ooh, there it is. Ouch.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course.
Can't say removed.
Describe specifically, other than the fact that it's different. Describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
That's problematic.
Yes.
That's a problem. That's a problem. That's backwards from what the defense is alleging.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
It's a tough way to answer this question.
As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously?
I have.
About a year ago?
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is Exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
Diamond towing.
That tow truck is diamond towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
That's the bottom left. Other
Can we
top.
play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area.
Hey, quit moving it.
This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please.
Okay, this is the biggest issue of this trial.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed?
Nope.
Or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back?
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but...
Did you at the time?
At the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't?
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
And you came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date?
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
Well, were you asked to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Will you ask questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed.
Time has passed, yep.
That you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed.
Correct.
That your report was respectfully scant.
Correct.
That you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer, and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
Sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
good-looking one down there on the right?
No, it was not.
Good-looking one. Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So, in your memory, in June 10, 2024, was that vehicle's rear tail light had a piece missing, correct?
Correct.
You said that your memory about the damage to the tail light, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
Now we've got transcripts. We're going to try to pick them apart on details here. Mr. Brennan has to attack this.
Your
This is
transcript of sworn testimony on June 10,
very
2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right? Yes.
So ask the question differently.
Okay. your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And I should take a look at that. Could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29th, 2022?
Spoiler alert, it's not going to be there. Brennan does his homework. So if your memory's bad about that, could your memory also be bad about how much of the taillight was missing? That's going to be Mr. Brennan's conclusion here.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you.
See if that rattles him.
So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that on the road you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah. Correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
Objection.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Over here.
Over here? Yeah. Excuse me, we approach. Mr. Brennan does the old "my eyes are up here" trick to him because he's glancing over at counsel table under questioning. This witness came in. We thought that was like a home run hit for the defense, and then he got caught in a trap, thinking he was asked about that very picture and asked questions about it. And Mr. Brennan has the receipts, and he was not before he proved to him that it hadn't come up. He tied the two together, right? He said, "And you're as sure about this as you are about this prior testimony." Yep. And guess what? The prior testimony is wrong. What does that mean? Very, very effective questioning. The witness still says, I saw what I saw, and that was not it. So the jury might still believe him, but they definitely, if they choose not to believe him, Mr. Brennan has done an effective job of giving them a reason why not to. So now it's really up to them. Do I know this prosecutor? I don't. Only what we observed through court here. Saw the taillight in the video. It was red. Marcia, I need to take my taillight apart. And show you that even with this entire red cover taken off, with the light turned on, it will turn red, even with no red plastic on it. The lights inside the LED lights are red lights.
You told us there was some background about being subpoenaed and timing. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation, about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June. Early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January?
Yes.
No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and...
Was it shown to you during your conference room meeting at the hotel?
It was not.
So you've looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, give me approach.
Okay.
Mr. Brennan is very, very good at this. It's very, very good at picking people apart here. How dare you not live under a rock? Yeah, this is Mr. Brennan's bread and butter. This is what he does. Hope you disagree that Mr. Brennan is good at this. He's a vicious cross-examiner.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence. You had a chance to see it in Dighton. If we could have the ring video at 5:07:58, please.
This is why I said it's problematic, because he's got the wrong part missing in his memory. It has the side missing instead of the front, the back portion missing. Aside from the judge, I'll count that one.
Have you seen this video before, sir?
I have.
Okay. Before you proceed, Ms. Gilman, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. I understand. Can we play this, please? Turn the sound down. Thank you.
That'll buff out.
Stop, please. Do you see that white part of the back rear right taillight? Objection.
I'm going to allow it.
You see that? Sir?
Whoa, he just backed up a
Can
frame.
you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue.
Just disappeared.
Stop it. Can you bring it back, Mr. Stone? Back more. Open, right there. Zoom, please.
Let's get the most grainy, snow-filled picture we can.
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dighton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day?
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dighton, you didn't go over it and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage. Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dighton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dighton. Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dighton?
I do not.
The right rear tail light and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay. Lights on, please. Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain this to the form, Mr. Jackson, as
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You're supposed to say
You
no.
remember being in Dighton, correct? Being called out to Dighton, to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dighton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sallyport in Canton PD? I'm sorry, in Canton, in the Sallyport at the police station?
I wasn't.
At 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sallyport at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sallyport?
Objection.
Sustain.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course.
Leading.
What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked but not, or damaged but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022, at about 3 or 3:15 in the afternoon when you saw the view? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Okay, that's all.
Wow.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up.
That's not evidence.
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set.
Thank you.
Wow.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses.
I have to tell you the same three
Those
things.
same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1. Okay? Thank you.
All rise for the court, please.
Half a day tomorrow.
Follow me.
If you're having trouble with the sound, you might want to exit and come back in. That is a YouTube issue. You'll notice that by the fact that most people are not having problems with the sound. Wow. I think as much as he could, AJ rehabilitated that witness to get him back as much as possible. Who won that round? I'd have to say that has got to be a win for the defense. You've got someone who the Commonwealth called for on their case in chief last time, uses their witness to say, yes, it was broken, who testified, who's had no dog in the fight, and says it doesn't match the picture we have now.
So there have been some motions, I think, piling up.
There's a pile of motions we need to address.
2 I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing
about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about. Sure.
Sidebar, Mr. Yannetti. I thought we had this talk already. We don't want to go sidebar. Let's do it in open court. I don't know what you're talking about, says the judge. We've got a pile of motions. Yes, there have been a whole bunch of things. She did not even mention some of the other motions, the more recent motions that are going to be on her desk when she goes back to her office, including the motion for an instruction regarding missing witness. Let's see. If AJ had to rehabilitate him as much as he could, how was that a win for the defense? I don't understand. Virginia, you've got someone who last time, first of all, he's a police officer in Massachusetts. Last time was called by the Commonwealth to use in their case in chief. Now gets called without any prep by the defense as far as what he's going to, the substance of his testimony. They just say, do you remember your testimony from before? Yes. Okay, good. We'll see you. And gives testimony, and his key point is the taillight as it is now, with all the red parts missing. He said that was not the condition it was in when I showed up when we first impounded the car. That it was broken, but not that badly. The problem is all the pieces. I mean, it could have been all pieces fell out while it was being transported. Well, they landed in the front yard where John O'Keefe's body was. That's where the pieces were found. That's a problem. That's planted evidence. If you believe this witness, you have to conclude that evidence was planted at the scene because all the pieces were found to put it back together except for one tiny piece. And that says dirty investigation. So that's the concern. That's why the Commonwealth had such an issue with this witness and his testimony. Let's see. What is convenient? I'm trying to call balls and strikes here as they happen in court. What's convenient? I don't know how you can conclude anything else. If you believe this witness, when he is shown the picture of the taillight, when he's shown the picture of the taillight and all this portion, okay, like all this entire thing is missing. This is just the portion, this entire thing, all the way down to like the corner down here. All this is gone. And he says, no, when I saw it, only part of it was missing over here. If you believe him, and all these pieces were found at the crime scene, the police took custody of the vehicle while plastic was still in the taillight. The red plastic was still there. The only conclusion is that it was planted. That's the only possible conclusion. If you don't believe him, then he's got a faulty memory. Just like the officer we had yesterday. She had, oops, I accidentally remembered people in the Sally Port next to the car. Clearly, somebody showed me a time card. I couldn't have seen that, so it didn't happen. How can you believe him when a photo taken before he saw it shows it was all missing? He has said that what he saw... first of all, the angle of the photo is different. So he said that what he saw was consistent. Every time he saw the photos, he says that's consistent with what I saw, and it didn't match that second picture. So all the photos, when the car's getting pulled on the flatbed of the truck, he says that's consistent with what I saw. When we see the picture, when he said that doesn't look like Reed's driveway, he looked at that. He said yes, that's consistent with the testimony. But when he's shown the picture of the taillight now with all the pieces missing, he says that's way too much. It was just missing a little bit. So let's see. All right. You guys need to be nice in chat, or we're going to just time people out for the day. If you're having a personal conversation with one person in chat, calling them out back and forth, just know you might get put in the naughty box for the day. It's causing problems in chat, and it's not adding to the conversation. All right. That goes for both sides of the conversation. Just know you've been warned. I know the mods have been working overtime and been generous and given limited timeouts, but all right. All right. Reasonable doubt sprinkled everywhere like Twilight, showing up all over, says Judy. RA needs a switch. Like a whip? Like a whip to whip switch people? No. Or like I need another button. I need more buttons for sure. The sidebar here, hopefully we get to hear some of this argument in open court. Of course, we don't know what they're talking about. There are some things like personal addresses and that we shouldn't hear. And the witnesses have been saying, even this last one, I don't feel comfortable saying this in open court where I was because I was at home. Taillight, not Twilight. Twilight's a good one as well. All right, the pics are deceiving in my opinion. The photos make it look smaller than RA shows this one, and it's huge. Mine is, it's the actual size. This is the actual model of taillight. This is the Lexus taillight. It's the portion that was broken. It's only the portion. It doesn't have the part that goes on the lift gate, because there's a portion of the taillight over there, some red as well, that's on the lift gate that's separate. Mine does not have that. But that was also not broken out in any of the pictures of Karen Reed's car. When I take pictures of small things, they also become huge in pictures. Dog Lover, thank you for that. Oh, man. Love to know what the jury is thinking. Well, there's only one way to find out, Lallyson, and that is to get to the end of this case and let them reach a verdict and then have them speak out. So I can see this going both ways still. I can see this going both ways. And the reason, and it should be pretty easy to see if we look at chat and just look at individuals who have listened to the evidence. Maybe they watched the previous trial. Maybe they've just watched this one, but they feel they've seen enough to form their own conclusion, and they're able to either exclude portions of testimony that the other side feels are pertinent, or rationalize them away one way or another. We have people on both sides who have rationally thought through this and reached a conclusion that differs from each other. And so a jury could see this both ways. No one's memory stays exactly the same. But the jurors are steadily in a state of confusion. Like I knew I was supposed to serve on the jury, but you guys, seriously, this is crazy. If you begin every statement with all due respect, would that protect you from a timeout? Yes or no? That's going to be the no category. What makes me sad, Camilla, what makes me sad is when the trial ends, we forget all about the people involved. I don't think we forget about it, but it is much easier to move on with our lives and with what we're focused on than say the family members of the victims, the individuals who testified. It's easy for us to not be associated with the outcome of the case long term, but not forget about. I mean, you think back to the last case that you felt a victim was wrongfully convicted. Say Zachariah Anderson. A lot of people look at that and think he's still. I mean, every day he wakes up and this is an unjust verdict. I mean, this is a poor outcome to the case. This was wrong. It's not that we forget about it, but we are still interested in other things as we go forward. Is there a civil case against Karen? I believe if there is, it's on hold pending the outcome of this case. I think there's no progress on that, but I'm sure there will be a civil suit. There's always a civil suit. I wonder how many jurors are regretting getting selected. Hopefully none of them. I mean, I realize that the majority of jurors in this country don't serve the length of term that these jurors in big trials serve. Most jurors will get like a 1 day or a 2 day or a 3 day. But this is a long one for sure. I would vote acquit and nothing else. Maybe there's 11 other young jurors who think like me and can smell BS when there's BS around. Charlie Raven, the FBI is still watching. I think they've said that the investigation is completed. I think we got a letter on the federal side that says there's no active investigation. Of course, that could change. It could be reopened. They always can. Is the business getting a new trial? I saw on Twitter that she was back in court and that she blew a kiss to the cameras today. No, thank you. I'll pass on that one. I don't know. I don't know if she's getting a new trial. I doubt it. There is a civil case waiting. And remember, for a civil suit, the bar is lower. To find culpability in a civil suit, it's a lower threshold than to find guilt in a criminal suit, in a criminal case. And so it's possible to have a not guilty verdict in a criminal case, but find civil culpability or civil liability in the civil case. They don't always go hand in hand. The attorney wants her to be unshackled for court. She has another attorney. Oh, good. You know how well that works? I'd like my client to please remove the spit mask, take her out of the restraint chair, let her move freely about the courtroom. He'll feel that way until he becomes the next attorney to be attacked by her. You know what we didn't see in this trial? We didn't hear a play-by-play depiction by the prosecution of how they believe the collision occurred, specifically with the movement of the body, the pirouette. I don't think we heard pirouette very much. I think defense might have mentioned it, but we didn't hear, like we heard the first trial, a very almost slow motion play-by-play freeze frame depiction of John O'Keefe being struck by the car. And I think that helps the prosecution because last time there, no animation. Yeah, we didn't, recreate this with clay or anything else. Last time the depiction was so precise that they offered that, and at the same time, there were points that they just couldn't account for. Like, he hit his head on the ground, and he pirouetted and fell and spun, and it didn't add up. We looked at that and we said, okay, I looked at that and said, okay, it might have happened, but not the way you say it did. I think the prosecution has benefited from not pinning that down so tightly that there isn't some wiggle room, and now the jury in their mind, if they're trying to envision this, can probably build a better scenario than, or one that at least works with them with the evidence they've heard. I wish they had done claymation. Wallace and Gromit style court reenactment. Morgan, I don't think they actually need to for a conviction. I was expecting them to do it because they did it last time, but that was Mr. Lally last time. This is Mr. Brennan. I was expecting them to give a play-by-play, right? Especially because we have so many experts in crash reconstruction, all the analysis that went into the tail light, the pieces, the broken glass. I was expecting that. All we have pretty much is just like a position of the arm. We just have this is how an impact could have occurred, and he ended up over there, and skipping the whole pirouette I think helped them a lot. Trooper Paul was was great. He was something else. What's physics? All right. Welcher did it with the glass in his hand and paint, but all at low speed, and it was just up to the collision point. We didn't have the full spin. I guess we started with the body. We ended with the body rotation after the collision. We didn't actually have that, and that's how he ended up on the lawn. They can't do a play-by-play. Oh, here we go. Looks like we're done. Let's see if we're done with the day or if we get an argument. Oatmeal, congratulations on 5 months. Judge is grabbing her stuff, standing, getting ready to grab an armful of goodies. Court staff is pretty much done for the day. One last facial expression from the court recorder. Let's see if... Nope. She said she's just... And it looks like we're done. Everyone's sort of doing the shuffle towards the door. It looks like all the motions possibly were argued at sidebar. Everyone's just doing a quick cleanup. The judge is in her departing mode. She has an armload of motions to review. And with that, we are back to the OnlyFans till tomorrow morning. What was that lip thing you did? It looked like the court recorder was going... What? I don't know what they call that. Don't... Phil... Knock it off. PJ, member for 13 months, says, thank you, mods, for your patience and commitment to harness this chat. You guys are great. Mods had to work a little overtime today. Thank you. Lally has on his comfy sneakers. Ooh.
Call from Angela.
Angela, I've got really bad audio right there. Oh, like terrible audio. What is wrong? Let's see. Are you there now? Hello? That was terrible. I think I fixed it, though. Replay the lip thing. No. I know where it ends up when I do that. That's the problem.
Call from Angela.
Angela, I'm just raising the volume there. Can you hear me now?
What?
Can you hear me now? Hello?
Yes, I can hear you. Yes, I can hear you. Sorry about that. A car was passing by. Wow. I don't know if I told you where I work, but some of the people in the chat know. I work at the hospital. And for the last week or so, I have been at the ER. And, of course, I found more than a few chatty doctors and nurses and asked. Of course, you know. And they say, yes, it could be from an animal or a dog. Those who saw dog bites and have experienced dog bites. And I asked them, is it possible for, a taillight to cause this or to cause the a car accident, a car versus pedestrian.
Right.
One very nice doctor told me, he told me that in any car versus pedestrian accident, there should be two sets of injuries. First set of injuries is the one caused by the car, and the second set of injuries is when he fell on whatever ground he or she fell on.
Right.
And those two sets should match each other, as in you can recreate what happened or propose what could have happened. We can't. I mean, Brennan can't do that. We do have two sets of injuries. We have a head injury and an arm injury, but they do not match each other.
Yeah. I think Mr. Brennan's questioning, particularly of the dog bite doctor, it was apparent that he was wording things in ways to try to catch her, and she caught on almost every time. And it's almost like he had to twist things a little bit to try to make his points. And she never really gave an inch on that one.
No. I have a feeling that she had an experience with people like Brennan and know how to handle them.
Well, I think she had experience with Brennan during the last hearing. That was a long one, so she's been there before as far as that goes. Speaking of Lally, sorry, Brennan Lally. Let me put this on screen. I was just looking at Mr. Lally in the gray suit here. If we back up, are those Heelys? Those. I'm not sure what shoes these are. He's got some comfy shoes on. Oops. I just zoinked it somewhere else. Never mind. It's long gone. I'll have to find it again.
Back to the taillight. So I just asked before I closed the shift, I asked one of the nurses if that could be a taillight, because who else knows about stuff? The nurses. They know everything. And she said the taillight has to be very sharp in order to, even let's say that he did broke the taillight. Mm-hmm. The taillight pieces has to be really sharp to cause those injuries.
Right.
How thick was the taillight? You put it into pieces. Like, how thick was it?
The taillight
thick
actually.
Enough to cause.
I haven't taken it apart yet. I still have it right here. But the taillight is, I can tell it is different thicknesses at different points, specifically the diffuser. There are some areas where it's very thick and some where it's very much thinner. So there are some parts of the taillight that are much, most of it I would say is probably about 1/8 of an inch. An eighth of an inch on the outer cover, and then some of the white parts are thicker.
Yeah, so 1/8 of an inch, and I have no idea what's that. How big or small is that?
So that's going to be
centimeters.
2 millimeters. I think it's 2 millimeters.
So, so that's tail. And she said, I don't know I don't know if that matches any of the ones. Maybe 1 or 2, but not the others. But it still does not make sense. It wouldn't have. Then he had the more than one layer of the tail had to have been broken in order to get those parallel scratches.
Yeah,
it just doesn't make sense.
I don't know. If the taillight impacted this area right here on the taillight, so we're looking at right here. If the elbow hit right here, and it passed this way across, and his arm passed this way across, size-wise, it matches up. Like me holding my arm. Let's see if I can do this here. My arm up against it.
An interesting.
It does fit. It fits, and if the cars all go in the same direction, it would make sense. The scratches would all probably be, across the arm and across the hand.
But in opposite direction than it is on John's arm. That's the problem.
That's the problem.
That does not match.
That's the problem.
Also, a fun fact or interesting fact, I looked that the tensile strength of a taillight, the polycarbonate plastic, is 9 times greater than tensile strength of the bone. More than 9 times. So there is no way.
There would be broken bone. If the taillight breaks, there would
not
be
just a broken bone. It will be broken bones, several bones.
Like a crushed elbow.
More like,
he would have had like a flexi joint for the elbow that would allow him to move in every direction.
Yeah, there is just no way. I mean, even at 40 kilometers per hour or 24 miles per hour speed, car cannot get that strength, that force in order for taillight to smash and he to not break the elbow. It's like mission impossible. I don't know how Brennan. I mean, how does Brennan seriously think that jurors are that not bright? And that they are going to buy what he is selling?
Well, I think he believes it. I'll give him that. I think Mr. Brennan believes what he is talking about. I think you can't fight as zealously as he has for this in this case, and not be convinced that you're arguing correctly.
Can you wait just a second?
Yeah, but if you order something, you have to order for me. Yeah, can I have a Big Mac, large fries? Maybe do you guys have Mountain Dew?
Yeah, I mean, speaking of one last thing, I totally agree with Oatmeal, what she said. I mean, with how he went against that sergeant, he is basically what's the word? Discrediting all his witnesses that has memory trouble.
Yeah.
It's like, who are you?
It has a two-edged sword. It definitely does.
Yeah.
And we've seen that with a couple of the things the prosecution has done. Angela, I'm glad you got to watch today, or at least parts of it. It was a good one. It was really good. Tomorrow, half a day tomorrow, we should have a snowplow driver.
Yeah.
We might have one other witness. It's going to be good. It's going to be good.
Yeah, I'm looking forward to it. Yep. Hopefully, there will be 2.5 weeks. I might actually be free for the verdict watch.
Yeah, I'd take the day off if I were you. Take a couple days off, plan some vacation. Angela, have a fun trip home and get some rest. I know it's late for you.
Yes.
We'll talk to you again soon. We'll see you. Bye.
See you. Bye.
All right, it's time for ARCA. Yeah, we can't wait for ARCA. That's gonna be wonderful. Let's see. It's time for ARCA. ARCA. We're not doing Free Willy here. It's ARCA. But yeah. See, one more call. This one's from Amber. Chat Mom is here. Hello, Amber.
Hello. How is everybody?
Good. How's the hurricane?
How's the hurricane?
It sounds like you're in a hurricane right now.
Oh, no. It's just my AirPods, or the knockoff version. Oh. Hang on. I can fix it. Is that better?
You fixed the weather. Hurricane has been canceled, guys. False alarm. It was just Amber's AirPods. Yeah, it's better. How are you doing? And she hung up on me. All right. She'll call back. She has my number. All right. Everyone be good. All right. I did pull up the Mr. Brennan's shoes, or sorry, Mr. Lally's shoes, just to look. Trying to see what style they are. I don't see a logo on this side. So we've got, he stands here for a second. Let me move over a teensy bit this direction. He's standing behind Mr. Brennan there. We'll give him a minute. People walk around. Now he comes out here. Here we go. Amber, you're back.
Sorry, operator error. I hit the wrong button.
What kind of shoes are these?
It happens, y'all. It happens. Wrong buttons tend to get
Skechers, maybe? We're trying to figure out what kind of shoes. We're trying to figure out what kind of shoes Mr. Lally's wearing. They look super comfortable. Nice white foam sole. It stands out in court, especially against the highly polished black shoes that Mr. Brennan has right next to him. But anyway.
So, did I miss anything Did I miss anything? I missed a lot today.
Yeah.
So, I've been kind of poking my head in and out today. So I know Dr. Russell was on the stand for a little while longer. There was a motion for mistrial that was, of course, denied, and some DNA stuff that got brought up. Aside from that spicy bit, was there really anything substantive from her testimony that came out after the DNA part?
Nothing that would be new for you. With your knowledge of her testimony. Her testimony was very consistent for the most part. I would say the big difference this time is when she was shown groupings of injuries, like if you divide the injuries to John O'Keefe's arm into 1, 2, 3, 4, and 5, as far as where the parallel lines are and how they go together. I believe this time she was more inclined to say some injuries were caused by canine teeth, whereas previously she said some were caused by either teeth or claws. And so her testimony did change a little bit, but it's still encompassed in her previous testimony. It's just now she seems more sure about something. And there was one that went the other way.
Was there anything from her testimony that was previously kept out that came in this time after the DNA?
As to the DNA,
Yeah, after the motion for mistrial was denied, which we all knew was going to happen. I'm going to have to go back and that argument because apparently that argument was off the wall.
it was pretty good. It took about an hour from when the motion was made to when the jury was back in front of the, in court hearing testimony again, with all the motion. The half hour the judge took to reason through her decision on that. It was pretty substantial. It was pretty neat. And it was sort of a lackluster finish when the judge was like, I'm going to deny it and allow the line of questioning. Proceed, please, Mr. Brennan. That was it. So.
Right. So I caught that. And then after Dr. Russell was Nick Barrows, right?
Yes.
And I don't know what all came out after he said that the taillight wasn't the way he saw it when he was helping.
With Mr. Barrows, Mr. Brennan did a very good job of catching him in the trap, a very common trap we've seen in court, where you're asked about your memory and how good your memory is now. You compare your mic drop statement you're making and saying you're sure about that, about as you are about this, and then proving that this part you're mistaken about. He did that with Officer Barrows. AJ did as good a job as you possibly could in rehabilitating him after that sort of impeachment. It's not like we're trying to say you're lying to the court. It's just like you remember wrong, But
right, you misremember something, but the substance that I was able to listen around the part where did you have a birthday 2 years ago?
Yeah.
Do you remember what day of the week that was?
Yeah. Tell us the day and we'll sing to you as well. So
does that end all of the witnesses for today, and we're supposed to pick up tomorrow potentially with Arca and Lucky, I presume?
I think so. I think that's where we are. Just half a day tomorrow. And it's going to be over before you know it. So.
All right. Yep. I've got lots of homework to catch up on tonight. Before tomorrow, which includes for everybody that's been putting in a form, Discord access form. I am trying to reach out, make sure you go in and edit your response for that form. If one of the mods can put that in the chat for me, that would be great because I'm driving. But some of you have asked for us to help you, and we can't directly message you in Discord because of your settings. So I need you to edit your response and give me a good email to contact you on.
There you go. Chat mom has spoken, so now you have to act. Thank you. Thank you, Amber.
All right.
Appreciate
Have a great day.
You too. Bye. Siebel, shame on me for what? For citing? I've been trying to call out wins, good moves on both sides, just as an observer of court. For the beginning, which one am I? What's the shame on you? You have no idea about this case, and you were jumping. I wouldn't say I have no idea. I would say I'm not personally affected in this case. I don't have a dog in the fight. I have not been on one team or the other throughout this, but I don't know. I'm surprised. Okay, have you watched the first trial? Yes. Watched a ton of. We covered the whole first trial here. I don't have the best memory, though. I've been trying to be neutral. I have personal opinions. I'll tell you, I share my opinions, but we do try to. Did you see the Commonwealth witnesses? Yes, every single one of them. We haven't missed a single minute of court. But no finger pointing. What I just want to say is that I do feel that here, as we watch court, that opinions on both sides are valued. Why? Because we get smarter, even if it doesn't change our mind. If we listen to someone else and listen to the rationalization and then explain our opinion and share our reasons for that, we can become smarter. It won't necessarily convert the other person to our opinion or switch us over to them, but we can understand the issues better. And if we can do that in a respectful way, it'll be awesome. It'll be great. Let's see. I have a photographic memory, but it is out of film right now, unfortunately. If somebody can find a place where I can order more film for my photographic memory, that would be great. Music, please. Music, please, says Carol. I've got things to do. We need to wrap this up. All right. Half of us are wrong and half of us are right. I usually am in the wrong category. I will own up to that. Statements like what? I'm confused. What did I say that was so wrong? I said that Mr. Brennan's very good at cross-examining. I've got my bachelor's. I'm practically an expert. All right. I can portal you over to Peter. That would be awesome. The lawyer you know is always interesting, always open with his opinion on where he stands on this case. If you do have any questions that you'd like to talk to me about specifically, or complaints or criticisms, feel free to call me directly. I honestly answer the burner phone myself, and I'm not above being corrected. I'm not perfect at this. I definitely am not perfect. So that would be great. Where's Peter Tragos? There he is. Oh, right there. 26. All right. We'll portal to Peter. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. Half a day tomorrow in court. It's going to be day 27 of the Karen Reed trial, round 2. So look forward to having you there. You guys have a great night. Be good to each other. We'll see you in the morning. And call me on the burner phone if you've got any questions or problems. Thanks. Bye-bye.